Mapepa ekumisa urongwa wekupushwa kwe2030 agenda iri kupushwa neZanuPF owanda kumadzitare edzimhosva mushure mekunge koita another activist anova wematongero wenyika oenda nemapepa anova ari mapepa ari kunzi parliament taken to court over CAB3 as activist demand national referendum. Kusangana kwatinoita pana paYouTube channel yenyu Magaba News patinobata nhau dzakasiyana-siyana dzinenge dzichiitika munharaunda nemunyika yedu yeZimbabwe, tichingoti kana pane vachangosvika pano paMagaba News ndiwo mukana wekubaya button rakanzi subscribe. Zuva ranhasi tauya takabata nhau yetsamba yakaendeswa nezuro kuHigh Court. Inova iri tsamba yakanyorwa ichiendeswa neapolitical activist uyo ari kuzivikanwa nezita rekuti Youngson Matete, anova akafaila mapepa kuHigh Court a case to block a constitutional amendment bill number 3 without referendum, achiti hapana kwainofana kuenda CAB3 iyi kana isina referendum yeruzhinji rwevana veZimbabwe. And also turikuona kuti nhau iyi patsamba yake ari kuendesa parliament yese kumadzitare edzimhosva kurakidza kuti ari kuti iyo parliament haigare pasi ichibvuma zveCAB3 pasina referendum, achiti ari kuipinza mudare redzimhosva. Ende tinoziva kuti vakapedzisira kuenda nenhau idzi dzeconstitution kumadzitare edzimhosva mawar veteran aimiririrwa navalove more madhuku nevakasiyana-siyana matop lawyers. So takaona kuti mawar veteran aya akaudzwa kunzi muparliament hamudhiskaswe nhau dzeCAB3 apasati dzapedzwa mukota hamudhiskaswe nhau dzeCAB3 pasati dzapedzwa muparliament. So nhau iyoyo ndio yakaita kuti nhau yemawar veteran imogadzikwe pasaidi. So uyo auya achitoendesa parliament yacho kukoti. According to mapepa muri kuona atakusira pascreen afaila kuHigh Court. According to news, a major legal challenge is made against Zimbabwe proposed constitutional amendment bill number 3, commonly known as CAB3, after Harare activist Youngson Matete approached the High Court seeking to stop key constitutional changes from being implemented without a national referendum. According to court papers filed at the High Court, Matete is asking the judiciary to intervene before Parliament and the executive process proceed with the bill. His application names the Parliament of Zimbabwe, President Emerson Mnangagwa, Justice Minister Ziyambi, the Zimbabwe Electoral Commission ZEC, and the Attorney General as the respondents. At the center of the case is the argument that some of the proposed constitutional amendment affect provisions that are protected under Section 328 of the Zimbabwe Constitution. Matete adds that such provisions cannot be altered solely through a parliamentary process and must first be approved directly by citizens through a referendum. In his application, the activist is seeking a declared order preventing the enactment and implementation of several clusters within CAB3 unless Zimbabwe are first given an opportunity to vote on them. The legal action comes at a time when debate across CAB3 continues to intensify across countries. Supporters of the bill is that the parliament has the authority to process the amendment, while critics believe some of the proposed changes are so significant that they require a direct public approval. Among the proposals attracting the most attention are planned to extend the term of office for the president, a member of parliament, and local authorities from 5 years to 7 years. The bill also contains proposals that would alter the way Zimbabwe elects its president. According to the court application, Matete believes these reforms represent fundamental changes to Zimbabwe democratic system and should not be implemented without the direct involvement of voters. In his founding affidavit, Matete adds that the constitution belongs to the people, that citizens have a constitutional right to participate directly in decisions involving entrenched constitutional provisions. He told the court that allowing the amendment to proceed without a referendum would deny Zimbabwe an opportunity to exercise that right. The activist further added that constitutional supremacy, democratic participation, and the sovereignty of the people should be affected if the proposed change are enacted exclusively through parliament. As the part of the relief being sought, Matete wants the High Court to declare that an attempt to implement the contest provision without first conducting a referendum would be unconstitutional and unlawful. He is also seek a order preventing Parliament, the President, and the Justice Ministry from taking any further step towards implementing the amendment until a referendum has taken place. In addition, the application asked the court to direct the Zimbabwe Electoral Commission to organize and conduct a national referendum if the bill successfully passed through Parliament. CAB3 was gazetted earlier this year and proposed several changes to Zimbabwe constitutional and electoral frameworks besides the debate around presidential and parliament terms, and the bill has general discussions regarding broader institutional and electoral reforms. Matete's court papers stated that the proposed amendment would significantly reshape aspects of Zimbabwe governance system, therefore required the direct consent of the electorate. The activist also points to concern raised by various civic, legal, and religious organizations. According to the court application, submissions from the Zimbabwe Catholic Bishop Conference and the Zimbabwe Council of Churches and the Law Society of Zimbabwe have highlighted questions about whether a referendum should be required before certain amendments take effect. The legal challenge now placed the issue before the court, where judges will be asked to determine whether the Constitution requires a direct public approval for the contest provision. Meanwhile, government officials and supporters of the bill have maintained that CAB3 can proceed through the existing constitutional amendment process without a referendum. Critics, however, continues to urge that the proposed reforms could have far-reaching implications for democratic accountability and constitutional safeguard. The case has added another important chapter to the ongoing national conversation surrounding the constitutional reforms in Zimbabwe. Political observers say the outcome could have a significant implication for how future constitutional amendments are handled, particularly when they involve provisions considered fundamental to the country's democratic framework. For now, the matter remains before the High Court and has not yet been heard. The court's eventual rule is expected to provide a greater clarity on the legal questions surrounding CAB3 and the roles of public participation in constitutional change. As Zimbabwe awaiting the next stage of the legal process, the debate over CAB3 continues to draw attention from political leaders and legal experts, civil society organizations, and ordinary citizens, all of whom are closely watching what could become a landmark constitutional cases. Mure Zimbabwe ndiona iri kubva kuna Youngson Matete uyo afaila high court case achiramba achiti hapana kwavanofana kuenda vanhu vekuparliament ava vasina kupiwa approval kuruzhinji rwenyika yeZimbabwe. So vanhu vari kuti parliament iyi inoratidza kuti iri captured, inozviteerera here kana kuti ichangoignowa zvataurwa naYoungson Matete uyo aendesa mapepa kumadzitare edzimhosva achiti ari kutora parliament, ari kuendesa zvakare vaziyambi ari kuendesa board rezeki, kuti board rezeki richange richigara pasi roona kuti ragadzirisa kuti vanhu vatokwanise kugadzirira kuti vavhote. So vamwe vakati this is good citizenship. We pray the honorable court answer your esteemed prayer in defense of constitutionalism and constitutionality. Vamwe vakati it's a far attempt how history has stated us that the results of your notable efforts are predictable well before they are released. People are encouraged to attend the public hearing and partake in process, but we know the outcome well in advance and our prediction were spot on. Wakati haini hangu handina mari kana ruzivo rwekuti kuconstitutional court kwacho kunoendwa sei, asi neshuwiro chekuda kuziva kuti CAB3 iyi yakanyorwa zviri pamutemo here, haisi iri kunze kwebumbiro remutemo here. Ndinorangarira ndichiverenga kuti kana pachida kuwedzerwa urefu hwenguva yekugara panzvimbo kwekuwedzerwa uku kunoiswa muCAB3 yakasiyana neCAB inoita kuti ari pachigaro panguva idzodzo agokwanisa kuenderera mberi. Sekuona kwangu CAB3 iri kukumbirwa kuisa zvikumbiro izvi pamwe chete, nokudaro ndinoona sekuti vari kuzviita vari kudarika kana kusateerera bumbiro remutemo. Ndo mashoko evamwe vangati power to you for this move, even though it's a male amount court exercise as the dice has already been rolled. The doctrine of separation of power died a long time ago, and this year judiciary, the judiciary no longer has unfettered power to check on the exigency of the executive and legislature. Thank you for standing for Zimbabweans. Vamwewo vari kutaurawo mashoko akasiyana-siyana vachiti tokutenda nekunyora kwawaita tsamba, asi maresults etsamba yako atogara apredictable, atobudiswa kudhara, sezvo veruzhinji vakutongoziva kuti zvinhu zvakaendeswa kukoti hapana kwazvinosvika nehurumende irimo munyika yeZimbabwe. What's your take on this? What's your take on this news? Ndidzo news dzatova takabata pano paYouTube channel yenyu Magaba News, patinobata nawo. Tokutenda nekutsigira kwamaita.